will be Ernest Trakas, who's an attorney. And Ernie will take us on a journey through the new guidelines being enacted around the globe and comparing those to present guidelines in the USA. And Ernie will also share with us his knowledge of current US litigation and how that might affect your gender practice on campus now and in the future.
What I'm going to talk about today is the provision of what we've been calling gender affirming care in the higher ed setting. Just to pose some questions and give our educators and administrators who are here with us today something to think about in terms of approaching the decision process with respect to the provision of gender affirming care. Before I start, I wanted to just thank GenSpec for including me. It's truly a high honor to be included among such illustrious presenters as well as the participants. So I'm very grateful and humbled by it. Okay, Laura, let's go. I think there you go. Okay, so just some background in the US. I put up here just some short quotes from Title VI of the Civil Rights Act and Title IX of the Education Amendments Act. As you all probably know, Title VI, passed in '64, began the process of establishing protected classes that provided that you could not discriminate against a protected class if your organization received federal financial assistance. In the '70s, you can go ahead, Laura, feminists, rightly so, began to use the same arguments to carve out protections with respect to sex. And in 1972, Congress passed Title IX, which prohibits discrimination on the basis of sex with respect to any entities that receive federal funding. And the reason I put these up here is to talk about just briefly this idea and as I said, feminists, rightly so, began to articulate the need to create a category based on sex. But what I do want to convey is that Title IX, despite Justice Gorsuch's decision in Bostock a couple of years ago, is very express and explicit with respect to its definition of sex. It does not include gender identity. It does not include gender preference. Now, these obviously are longstanding debates and arguments that will continue, but the simple fact of the matter is that Congress has not had the will yet to change the definition that it put in Title IX back in 1972. And so as these cases progress, and eventually some Title IX case will make its way to the Supreme Court and we'll have an answer, whether or not I'm right or my other colleagues may be right. But I do believe that the definition in Title IX is pretty express and explicit. And so when we start to bleed into these other areas of gender identity and gender preference, it makes it a little more difficult. So that's just a little bit of background for you. Okay, our next slide, please. All right, so state of play. What I wanted to do, if you could back up just one little bit for me. Okay. What I mean by state of play is what's been going on recently with respect to Title IX and complaints relevant there too. And I picked 3 higher ed ones just simply to point out that we've got a very what I call highly engaged cohort now, whether that is amongst professional educators. Every case that I cite here that were complaints filed with the Office of Civil Rights were brought by faculty members against universities. Ironically enough, but appropriately so in my opinion, challenging women-only programs that had been established under Title IX as violative of Title IX because it excluded men. And I only point them out simply to show that we're in a time of what I call heightened engagement across the board, whether it's in professions, parents, as we've seen in the recent elections at school boards, and what have you, and challenges in court. Okay, next slide, Laura. Thank you. As far as federal litigation, I've cited a few cases here that are fairly recent, since 2020. The first three are against K through 12 public school districts, alleging encroachment upon parental rights based on K through 12 schools engaging in gender affirming policies and protocols outside of parents' consent and knowledge. But the one I want to focus on for you is Brandt v. Rutledge at the bottom there. That's currently in the United States Court of Appeals in the 8th Circuit. In that case, the state of Arkansas passed what it called the SAFE Act, which prohibits healthcare professionals from providing gender affirming care to youths under the age of 18. That statute was immediately challenged by the American Civil Liberties Union, and incredibly, it's morphed into, they might have 5 or 6 dozen different amici that have entered and filed briefs in the case. It's awaiting scheduled argument now, so my expectation is that the Brandt v. Rutledge case will be decided sometime this year, and it'll have an impact on what we're going to talk about in terms of standard of care. Okay, Laura, go ahead, and we'll circle back to that. So gender affirming medicalization, go ahead, Laura. In the higher ed setting, campus healthcare centers, in some instances, and in many instances, are serving trans students' needs, prescribing and overseeing hormone treatment. Counseling centers are including either counselors who identify as trans or are highly trained, and nothing wrong with that. And then, does the student health insurance cover this trans affirming care? These are questions that I'm sure all of you have different perspectives on and probably have pondered. Go ahead, Laura. Just some statistics for you. As of a couple months ago, 148 colleges and universities cover hormone and gender affirming surgeries for transitioning students. At least 28 of them cover hormone therapy. Okay, Laura. So the big issue is what standard of care is being applied in determining the need for an appropriateness of gender affirming medicalization, whether that means hormone treatment or surgical intervention. Okay, Laura, go ahead. Now, in my experience, in almost every case I've encountered, and I'm involved in many, the World Professional Association for Transgender Health's alleged standard of care is what's been promoted, if not utilized. Okay, Laura. Now, this standard of care, as we've heard today, is based on a Dutch model. That model, and it's important to point out because I'm going to try and convey here as briefly as I can, the differences and distinctions between the Dutch model and the ultimate WPATH 7 so-called standard of care that was adopted. In the Dutch model, it was predominantly male subjects. The Dutch disqualified mental health comorbidities across the board. Medicalization was only directed to a select group with fully documented gender dysphoria. And then the protocols were designed to guard against any false positives so as to prevent unnecessary harm, as we heard from Dr. Cruz and others today. So that was essentially the essence of the Dutch model. Now, what are the WPATH guidelines? And that's what I call them. I don't believe WPATH rises to the level of the classic standard of care. They didn't follow the strict requirements of the Dutch model. We've kind of heard a bit about that already. It omitted the independent confirmed evidence of persistent dysphoric symptoms. WPATH guidelines based solely on subjective report of the student. If the student or the young adult claims that they've had persistent gender dysphoria, it was accepted as such. A diagnosis then was made without review by qualified mental health professionals. And the research that they based their guidelines on was based on male clients or male patients that cannot and should not be generalized to females. And as we've seen with our other presenters, whether it was Stella O'Malley or Mr. Kimberly, the incredible exponential increase in female gender dysphoria, or at least claimed gender dysphoria in the last 5 years is, as I said, exponential. So you cannot just take the Dutch study and apply it to females. Okay, Laura, which is what WPATH did. They also, it's not designed to address the current presenting population, which again speaks to this increase in females presenting with gender dysphoria. And it doesn't require adequate protocols to avoid unnecessary medical harm, whether that is psychological intervention or at least evaluation and forensic analysis, what have you. And finally, and most importantly, I think from a purely legal and liability standpoint that higher ed administrators should think about, this guideline enables medical professionals to avoid accountability because there is no double blind, if you will, or no effort to try and make sure that comorbidities have been considered or that mental health evaluation has been undertaken. So I would just urge you to think about that as we talk about whether or not the WPATH guidelines are a credible standard of care or so-called standard of care. Okay. Okay, now currently in draft form is what's being called the WPATH Standard of Care 8. And just a couple of points that are being tossed around now with it is this general assumption that to treat with hormones and surgery as a default, based again on almost exclusively the sole report of the patient or student. The embracement of this idea that hormonal intervention should be widely available, that the patient or student's desire is the ultimate eligibility criteria, relegating comorbidity and or psychological evaluation to tertiary status. And then inability to consent should not be a barrier. And I didn't read that incorrectly. That is, in fact, something that is in the draft. Okay, Laura, go ahead. So we have to ask the question, is the WPATH guidelines or so-called standard of care objective or biased? And we've heard some talk today about the affirmation approach and ideological assumptions. And what's important from a legal and liability standpoint is this concept or position anyway, that once you have too much presence of activism, and I'm not necessarily lumping activists within advocates, but once you've taken this ideological position and run with it, it's hard to be objective and hard to follow traditional clinical practices. Anyway, here's a quote from Lynn Fraser. WPATH is not the typical professional organization that develops clinical practice guidelines. WPATH is a hybrid professional activist organization. Okay, Laura. So we have to think twice before you just simply embrace their guidelines or their professed standard of care. In 2022, its own leadership acknowledged that there's no medical consensus on treatment best practices, whether that's hormonal intervention, surgery, or other less invasive measures, whether that's psychological counseling, whatever the case may be. And there is a lack of consensus on a global basis with respect to the standard of care. You see that now when you look at what's being reported. We saw some of it today from Scandinavia, whether it's Sweden or Finland or in Australia or New Zealand, all now are starting to question whether or not the WPATH guidelines, as I call them, rise to the level of a standard of care and should it be adopted. And here is from Dr. Laura Edwards-Leeper, who we heard from earlier, who chaired the committee on the revision of WPATH standard of care that we just looked at their draft. We've gone to another extreme, which is moving people forward pretty quickly to medicalization without proper assessment and mental health supports. We're not all on the same page. That's from the own organization, WPATH. Okay, Laura. So as higher ed administrators or clinicians, what are you to do? And from the perspective of my world, and how do you protect yourselves and your institution from what may be unnecessary litigation? Because I said we've got a highly engaged and motivated populace now that are emboldened in terms of taking on issues and causes that in the last 10 years or 10 years ago probably would not have been given a second thought. So at a minimum, review your current policies and protocols applicable to your decisions to treat, whether that's through your clinics, mental health counseling, whatever it may be. Is the diagnosis and treatment decision made in conjunction with independent confirmation or differential neuropsych assessment by qualified mental health professionals? And again, with that, supported by diagnostic tools, whether those are inventories, what have you. Or is your treatment decision based solely on subjective report of a student along the lines of the WPATH guidelines? I think if it's the latter, then you're leaving yourself and your institution open to a legitimate argument with respect to the validity and soundness of that decision. And then of course, the attendant liability for any damage or harm that's done as a result of that decision to treat. Okay, Laura. One more, back up one more, okay. So assure that you've got a comprehensive assessment, not just a report of the student. Assure that if you decide to treat, that it is evidence-based, and we've heard plenty about that today. Make sure you adhere to the relevant laws and professional standards in assessing the capacity and obtaining consent. And again, going back to the WPATH draft for standard of care number 8, this business about obtaining consent is radically important. Because it could come back to haunt you after the fact. So just be very, very cautious about that. Remember, as of now, there's no agreed upon standard of care. It does not exist. And this takes us back to that case I mentioned, Brunt v. Rutledge. One of the arguments in that case that's currently before the U.S. Court of Appeals is in fact the lower court's embracement of a WPATH so-called standard of care, whether or not a standard of care exists, whether or not that standard of care was valid. And so obviously it will maybe set up a higher court argument, but I expect in this year, before this year's out, that Court of Appeals to decide and include it as part of that decision, whether or not this WPATH standard of care is in fact a standard of care, nothing more than a mere guideline. And then lastly, obviously, access your general counsel or your attorney in terms of your policies and protocols as far as providing gender affirming care going forward, because it is an issue that is in the mix right now. There's no clear legal position right now with respect to the provision of gender affirming care. And then certainly if it's based on WPATH alleged standard of care, I would argue that you're on pretty thin ice. So I'll let it go at that, and I'll be around for questions. Again, thank you all so much for putting up with me today and my inability to work the screen.